Courtrooms are supposed to be temples of logic, justice, and order. But sometimes they turn into comedy clubs with judges in robes. Welcome to a world where people sue soda companies for not giving them wings, where sandwiches end up on trial, and where someone once tried to drag the Almighty himself into court. Today we're counting down 33 ridiculous lawsuits in America, the ones so bizarre, so over the top, that they make you wonder how the judge kept a straight face. Some of these cases dragged on for years, some were thrown out in seconds, but all of them prove one thing: the human imagination has no limits, especially when it comes to filing nonsense in front of a jury. So grab your popcorn, silence your cell phones, subscribe Factoland, and prepare to hear about lawsuits that range from "you can't be serious" to "this actually changed the law." Let's get into it. Number 1. This is the crown jewel of courtroom nonsense. In 2005, Washington, D.C. Judge Roy Pearson dropped off a pair of pants at his neighborhood dry cleaner. They misplaced them. For most people, that's annoying, maybe worth a stern complaint, or at worst, a refund. But Pearson, he went nuclear. He filed a lawsuit demanding $54 million. Yes, over trousers. Why? Because the store had a sign in the window that said "Satisfaction Guaranteed." He argued that this wasn't just an advertisement, it was an unbreakable contract. According to him, that contract was worth enough money to fund a small country's space program. The case dragged on for years, nearly bankrupting the family who owned the shop. Pearson eventually lost, but not before turning himself into a national punchline and forcing the courts to remind everyone, no, you cannot sue someone into oblivion over a pair of pants, even if they were your favorite pair. Number 2. 2 years later, in 2007, Nebraska State Senator Ernie Chambers decided to go bigger. Forget suing a business, forget suing a person, he filed a lawsuit against God. Yes, capital G, the Almighty. He asked the court for an injunction to stop God from unleashing fearsome floods and horrendous hurricanes. And here's the wild part. The court didn't throw it out right away. A judge actually entertained the filing. The case was only dismissed because the court couldn't serve God with the paperwork. No address, no trial. Which means technically, God remains undefeated in court. Not because of divine power, but because he doesn't have a P.O. box. Somewhere out there, Senator Chambers is still waiting for the bailiff to track down the creator of the universe. Number 3. And then there was Robert Lee Brock, an inmate in Virginia who came up with what he thought was the ultimate legal loophole. He sued himself for $5 million. His argument? By getting drunk and committing crimes, he had violated his own civil rights and religious beliefs. Since he was in prison and obviously couldn't pay himself, he demanded the state step in and cover the damages. To himself. A flawless financial loop, right? The judge, probably struggling to keep a straight face, dismissed it immediately. But the case lives on in law school classrooms as the perfect example of a frivolous lawsuit. A man literally trying to get rich by suing himself. Number 4. In 2008, the mayor of a Turkish city called Batman decided Christopher Nolan and Warner Brothers owed him big. Why? Because Nolan's The Dark Knight was dominating theaters, and the mayor claimed the studio had stolen the name of his city. He insisted this cinematic theft caused a rise in crime and even psychological trauma for his citizens. Yes, according to him, Batman made people commit crimes. We're in Batman. Unsurprisingly, the lawsuit never even made it into a courtroom, but it did give the world an unspoken rule: don't sue Batman. It also proved once again that sometimes the court of public opinion delivers a harsher verdict than any judge ever could. Number 5. Back in 1997, a psychic sued NASA for $300 million. Why? Because she claimed their Mars Pathfinder rover had trespassed on Mars. She called herself a Martian ambassador and insisted the rover's cold robot wheels were disrupting the planet's vibratory balance, which of course interfered with her psychic powers. Translation: your robot killed her vibes. The court dismissed the case faster than a blurry UFO video gets debunked. Still, this case gave us a timeless legal truth. If you want to sue in the United States, you generally need to be from planet Earth. Sorry, Martians, aliens, and people who think they're Martians after 3 energy drinks. No jurisdiction. Number 6. We've all ordered an iced coffee only to discover it's basically an ice sculpture with a splash of caffeine. Annoying? Yes. Criminal fraud? Well, one Chicago woman in 2016 said absolutely. She sued Starbucks for $5 million, claiming their venti iced drinks were half ice, half disappointment. The judge dismissed the case, pointing out that even a 6-year-old knows ice takes up space. Honestly, what was the alternative ruling? That Starbucks has to serve 24 ounces of pure coffee plus ice? At that point, your drink would come in a gas can. This case reinforced the reasonable consumer standard, which is legal jargon for don't sue physics. Number 7. In the 1990s, Richard Overton was watching Bud Light commercials where dudes on the beach cracked open a cold one and instantly got swarmed by models. He thought, wow, finally, a beer that doubles as a dating app. So he bought Bud Light, drank Bud Light, and waited for the women to appear. Spoiler alert, they didn't. So he sued Anheuser-Busch for false advertising, claiming emotional distress. The case was dismissed, but not before giving us the wonderful legal concept of puffery, exaggerated marketing promises no sane person is supposed to believe. That's why Red Bull can say it gives you wings without you actually flapping off the couch. Number 8. Some people file lawsuits like it's a hobby. California got so tired of one guy's antics, they basically invented a legal timeout. It's called the vexatious litigant label, and once you've earned it, you can't file new lawsuits without a judge's permission. The man who inspired it had filed over 300 lawsuits, all from one minor car accident. He sued the driver, the tow truck operator, probably the guy at the gas station who sold him gum that day. Eventually, the court said, "Sir, this is not Build-A-Bear. You can't just keep making lawsuits until you're happy." Think of it as the courtroom equivalent of taking away someone's crayons because they drew all over the walls. Number 9. A man in Michigan won Subway's Subway for Life contest. Sounds amazing, right? An endless buffet of sandwiches until the end of time. Except when he got his prize, it was about $13,000 in gift cards. That's like, what, 3 months of rent and a handful of footlongs? The guy sued, arguing for life meant actual unlimited sandwiches until the Grim Reaper himself told him, "Time's up." The court sided with Subway, saying companies get to define their own terms, which honestly saved the chain from financial ruin. Because if they had to feed one dude forever, that man would become a one-man economic crisis. Number 10, the McDonald's hot coffee lawsuit is the most misunderstood case in America. Everyone thinks it was some greedy old lady who spilled her drink and wanted millions. Nope. Stella Liebeck was 79 years old, and the coffee wasn't just hot. It was lava. McDonald's served it at a temperature that could cause third-degree burns in seconds. She suffered horrific injuries and needed skin grafts. In fact, McDonald's had over 700 previous complaints and still did nothing. The jury's award wasn't coffee spilled equals jackpot. It was punishment for corporate negligence. McDonald's PR machine spun it into a joke, and now everyone thinks it was frivolous. But the reality is, she wasn't suing over a little drip on her lap. She was suing because McDonald's was basically handing out coffee that doubled as industrial paint stripper. And hey, before we roll into the next batch of insanity, if you're enjoying this list of courtroom comedy, smash that like button and subscribe. Otherwise, someone's probably already drafting a lawsuit against us for emotional distress caused by laughter. Number 11. Remember that monkey selfie that went viral? A grinning macaque snatched a photographer's camera, snapped the most majestic self-portrait in animal history, and instantly became more photogenic than half of Instagram. Then came the lawyers. PETA marched into court demanding that the monkey, now nicknamed Naruto, owned the copyright. Yes, they wanted the monkey to be legally recognized as the photographer. A federal court had to sit there and seriously consider whether a monkey could own intellectual property. The answer, shockingly, was no. The judge basically said, "Nice picture, little guy, but you're not getting royalties." Still, this furry influencer managed to force the US Copyright Office to add a rule. If you're not human, you can't own a selfie. Sorry, monkeys, ghosts, or any haunted typewriters out there. Number 12. Alan Heckard, a man from Portland, decided life had dealt him an unfair hand. His curse? Looking too much like Michael Jordan. People constantly mistook him for the NBA legend, asking for autographs, staring at him, and making his life unbearable. So, naturally, he did the only reasonable thing. He sued Michael Jordan and Nike for $800 to $32 million. Because apparently, looking like a millionaire means someone owes you millions. The case was dropped, but not before the entire planet pointed and laughed. Legal lesson: you can't trademark your face. If you look like Beyoncé, congrats. If you look like Michael Jordan, sorry. That's just genetics, not a payout. Number 13, Fruit Loops. A cereal so colorful, it looks like a unicorn exploded in your bowl. For decades, kids shoveled it down without a second thought. But in 2009, one California man was outraged. Not by the sugar, not by the artificial colors, but because there was no actual fruit in Fruit Loops. He filed a lawsuit claiming Kellogg's was guilty of false advertising. The judge dismissed it instantly, pointing out that the word fruit isn't even spelled right. If you thought fruit meant vitamins, that's on you. The case reinforced the reasonable consumer standard, which basically says if you thought neon rainbow rings were part of a balanced diet, maybe the law can't save you. Number 14. In 1981, Arnie Cheyenne Johnson tried a defense strategy that sounds like it was stolen from a horror movie marathon. He stabbed his landlord to death and told the court with a straight face that he wasn't guilty because he had been possessed by a demon. That's right, his lawyers literally argued that Beelzebub had taken the wheel. The judge, probably wishing for holy water at that point, dismissed the defense immediately, saying, "Supernatural forces don't hold up in a court of law." This case ended up creating a rock-solid legal precedent. "The devil made me do it" is not an acceptable excuse. Imagine if it had worked. People would be blaming ghosts for speeding tickets and goblins for tax fraud. The only thing scarier than demons would be the chaos of everyone suing Satan for damages. Number 15. David Copperfield is known as the magician who made the Statue of Liberty disappear. But in a Las Vegas courtroom, he ended up making something else vanish: his career mystique. During one of his shows, a tourist was picked to join an illusion where audience members vanish from the stage. The trick involved hustling people through secret back hallways in near total darkness. Surprise, surprise, one guy tripped, fell, and got hurt. He sued Copperfield, forcing the magician to reveal his illusion, step by step, under oath. Imagine being a lawyer writing, "And then, Your Honor, a stagehand waves his flashlight to trick the audience." Copperfield eventually won the case, but the trick was ruined forever. For a man whose career depended on mystery, the lawsuit was like sawing himself in half, with no assistant to help put him back together. Number 16. Most of us have at one point blamed our parents for messing something up. But one 28-year-old New Yorker decided to raise the stakes. He sued his mom and dad for $200,000, accusing them of malpractice of parenting. His claim was basically, they didn't love me enough, they didn't support me enough, and now my life is terrible. The judge dismissed the case faster than you can say, "Clean your room." But imagine if it had succeeded. Every family argument in America would turn into a potential lawsuit. Didn't get a bike for your birthday? Sue, your sister got a bigger slice of cake? Call your lawyer. Fortunately, the court drew a line, officially stating, your parents might owe you dinner and maybe a lecture, but they don't owe you 6 figures for a bad childhood. Number 17. Weather reports are wrong all the time. Most of us just shake our fists at the sky and move on. One woman turned a bad forecast into a payday. The local station predicted sunshine, so she dressed light. It rained. She caught the flu, missed a week of work, had to buy medicine, and decided someone had to pay. That someone was the TV station. And here's the kicker. She won over $1,000. That's right, the weather team literally had to pay for the rain. Afterward, broadcasters everywhere learned to cover themselves with vague phrases like a chance of rain or scattered showers. Not because it's accurate, because if they promise sun and Mother Nature disagrees, suddenly they're on the hook for flu medicine. Number 18. Here's why product warnings have become so painfully obvious. A man in California was cruising along on his BMW motorcycle, which had a throttle lock, basically cruise control. He set it, then decided to let go of the handlebars to dig through his backpack. Naturally, the bike crashed. Instead of admitting he'd been reckless, he sued BMW for not warning him that letting go of the handlebars while moving might be a bad idea. The court dismissed it immediately, but manufacturers took note, terrified of becoming the next courtroom clown show. Now we all live in a world where irons come with labels like "Do not iron clothes while wearing them," and peanut butter jars say "may contain peanuts." All thanks to one guy who thought he could ride hands-free like he was auditioning for the Fast and the Furious. Darwin Awards edition. Number 19. Haunted houses exist for one reason: to terrify you. That's the deal. You pay money, you get scared, you laugh about it later. But one woman at Universal Studios' Halloween Horror Nights wasn't laughing. When an actor in a scary mask jumped out, she fainted, hit the ground, broke her wrist, and sued Universal for making the haunted house too scary. The judge sided with the theme park, pointing out that fear is literally what she paid for. Imagine if she'd won. Next time you go on a roller coaster, you could sue for it being too fast, or sue a clown at the circus for being too creepy. The ruling reinforced a critical principle: assumption of risk. Buy a haunted house ticket, you're agreeing to be scared. If that's too much, maybe try the petting zoo instead. Number 20. Subway's famous footlong scandal was a masterclass in overreaction. In 2013, someone measured their sandwich and found it was only 11 inches long. Outrage exploded online. Suddenly, everyone was measuring their bread with rulers. This outrage quickly mutated into a full-blown class action lawsuit. Years passed, lawyers collected millions in fees, and Subway got dragged through the media mud. And what did the customers get? Nothing. Not a penny. The only people who walked away fed were the lawyers, who pocketed over $500,000. The judge himself called the settlement utterly worthless. So if you thought you were cheated out of 1 inch of bread, the real scam was paying legal fees taller than the sandwich itself. Number 21. If you've ever heard someone joke about the Twinkie defense, this is where it came from. In 1978, San Francisco politician Dan White shot and killed Mayor George Moscone and Supervisor Harvey Milk. His lawyers argued that his sudden switch to eating Twinkies and junk food was a symptom of depression that impaired his mental state. But the media twisted it into the idea that he was claiming Twinkies made him do it. The jury bought the diminished capacity argument, convicted him of a lesser charge, and the public lost its collective mind. People rioted. California lawmakers ended up abolishing the diminished capacity defense entirely. So technically, a tragic case mixed with a snack cake ended up reshaping California criminal law. And poor Twinkies, forever blamed for something they didn't do. Number 22. The 1990s gave us flannel boy bands and Pepsi's Pepsi Stuff campaign. Collect enough points from soda bottles and you could get prizes. Their commercial jokingly showed a kid landing a military-grade Harrier jet at school, complete with a caption, 7 million Pepsi points. Enter John Leonard, a 21-year-old business student with too much time and confidence. He discovered a loophole where you could actually buy points in bulk. He raised $700,000, sent Pepsi a check, and said, "Where's my jet?" Pepsi refused, and the lawsuit was on. The court sided with Pepsi, saying no reasonable person would think the ad was serious. But Leonard still went down in history as the guy who actually tried to barter soda caps for a fighter jet. Frankly, that kind of audacity deserves at least a free lifetime supply of Pepsi. Number 23. What is a sandwich? No, really. That was the central issue in a Massachusetts court case. Panera Bread had an exclusivity agreement in a mall saying they were the only ones allowed to sell sandwiches. Then a Qdoba Mexican grill tried to move in. Panera sued, arguing burritos count as sandwiches. Lawyers hauled out dictionary definitions. Experts testified about bread structure and fillings. At one point, a judge had to seriously consider beans and rice as legal evidence. In the end, the court ruled, a burrito is not a sandwich. And just like that, the culinary universe got a legal boundary line. Somewhere, tacos and hot dogs breathed a sigh of relief. Number 24. In 2021, pop superstar Mariah Carey released her memoir, spilling plenty of family tea. Her brother wasn't thrilled with how he was portrayed and sued her for defamation. He claimed her memories caused him emotional distress and ruined his reputation. The court mostly threw out his claims, ruling that Carey's memoir was presented as personal recollection, not objective fact. Translation: you can't sue someone just because their version of family history makes you look bad. The precedent was important. It reinforced legal protection for memoirists, which is good, because if siblings could sue over embarrassing childhood stories, every family reunion would end in subpoenas. Number 25, hotel magnate Leona Helmsley passed away in 2007 and left a jaw-dropping $12 million to her Maltese dog, Trouble. Meanwhile, she left nothing to two of her grandchildren. Naturally, the grandkids sued. A judge eventually reduced the dog's inheritance to a mere $2 million, which was still enough for Trouble to have more financial security than most humans. The fallout? States across the U.S. passed new pet trust laws, allowing owners to leave money to care for their animals after death. So thanks to one spoiled pup, estate law was permanently changed. Somewhere, cats are already plotting their own multi-million-dollar wills. Number 26. You've probably heard the urban legend. A burglar breaks into a house, gets hurt, and successfully sues the homeowner. While the wildest versions are fake, they are rooted in a real legal principle. Homeowners do have a duty of care even to trespassers. Specifically, you can't set up malicious booby traps. Cases where criminals injured themselves while trespassing led to public outrage, and lawmakers responded with castle doctrine and make-my-day laws. These laws gave homeowners more legal protection if they injure intruders while defending their property. So yes, dumb lawsuits really did inspire new legislation, proving once again that criminals can sometimes be the best lobbyists. Number 27. The Winnebago cruise control story is one of the greatest urban legends in lawsuit lore. The tale goes like this. A man bought an RV, set the cruise control to 70 miles per hour on the highway, and then calmly walked to the back to make himself a sandwich. Predictably, the RV crashed. He then allegedly sued Winnebago for not warning him that cruise control did not mean autopilot. Whether the case actually happened or not is doubtful, but the fear of lawsuits like this pushed manufacturers into plastering every product with absurd warning labels. That's why your lawnmower says "do not lift while running," and your coffee cup says "contents hot." It's not because companies think you're stupid, it's because someone out there has already proved they are. Number 28. Can you own a sound? Harley-Davidson thought so. In 1994, they tried to trademark the distinctive potato, potato, potato rumble of their V-twin motorcycle engine. Competitors immediately challenged them, and a 6-year legal battle over noise broke out. After millions in legal fees, Harley finally gave up. The case forced the U.S. Patent and Trademark Office to draw a line. Functional sounds from machines can't be monopolized. So yes, Harley failed to own the sound of its own bike, but on the bright side, they saved the world from a dystopia where every sound effect you hear might belong to a corporation. Number 29. Mark Johnston went on a Vegas bender, lost $500,000 at a casino in a single weekend, and then sued to get his money back. His argument? He was a compulsive gambler and was visibly drunk, so the casino had a duty to stop him. The Nevada Supreme Court disagreed, ruling casinos are not responsible for saving gamblers from themselves. Imagine if he'd won. Every poker table in America would be full of people screaming, "It's your fault I lost," at the dealer. The ruling saved casinos billions and established the principle: the house always wins, and the courts aren't going to bail you out. Number 30. Remember the Fruit Loops lawsuit? Well, in 2009, a woman went after PepsiCo over Captain Crunch's Crunch Berries cereal. Her claim: she believed Crunch Berries were real fruit. For 4 years, she ate the cereal before learning the shocking truth that the brightly colored little balls were just sugar and corn. She sued for false advertising. The judge dismissed the case with a level of sarcasm usually reserved for sitcoms, pointing out that no reasonable person could confuse rainbow puffs with actual berries. The ruling cemented the idea that the law will not protect you from a complete lack of common sense. Translation: if you thought the captain was steering a ship full of fruit, that's on you. Number 31 Red Bull gives you wings, unless it doesn't. In 2012, a Michigan man cracked open a can of Red Bull and realized something devastating. No wings, not even a little flutter. In fact, despite years of chugging the energy drink, he hadn't sprouted feathers, achieved superhuman performance, or taken flight even once. Outraged, he sued Red Bull for false advertising. Now you'd think a judge would laugh this straight out of the courtroom, but Red Bull didn't want the embarrassment of a full public trial. Instead, they settled for $13 million. Customers who had bought the drink in the previous decade could claim $10 in cash or $15 in Red Bull products. Congratulations, the company paid millions just to avoid explaining that wings was a metaphor. Meanwhile, the rest of us learned that if you take ad slogans literally, you might just cash in big. Number 32. For over a century, every time someone sang Happy Birthday in a movie or at a restaurant, Warner/Chappelle Music swooped in demanding royalties. They claimed to own the copyright to the song. That's right, the most common tune in the English language was basically paywalled. Enter one fed-up documentary filmmaker in 2013 who refused to accept paying fees to sing Happy Birthday on film. She sued, and during the case it was revealed that Warner's copyright claim only covered a specific piano arrangement from 1935, not the song itself. A judge ruled Happy Birthday was public domain all along. The result? One lawsuit dismantled a multi-million-dollar monopoly and gave the world back its birthday anthem for free. Thanks to this, you can now sing Happy Birthday at Chili's without some lawyer crawling out from under the table with an invoice. Number 33. And finally, meet Andrew Rector, a Yankees fan who achieved immortality in 2014. For the simplest of reasons, he fell asleep at a baseball game. ESPN cameras caught him snoozing during a Yankees-Red Sox matchup, and the commentators made a few lighthearted jokes about him. Rector did not appreciate being broadcast to the nation as the guy drooling in the cheap seats. So, naturally, he sued ESPN, the commentators, and Major League Baseball for $10 million, claiming defamation and emotional distress. The judge dismissed the case, noting that Rector was, in fact, asleep, and the commentary was tame. The ruling reinforced broadcasters' rights to comment on the crowd without fearing lawsuits every time a fan picks their nose on camera. Rector didn't win his millions, but he did win the permanent title of Baseball Nap Guy. Somewhere out there, his lawsuit is still snoozing. And there you have it. 33 lawsuits so ridiculous they make you wonder how some people even found the courthouse doors. From suing sandwiches to suing God, America has truly perfected the art of turning nonsense into legal drama. The lesson? Judges aren't just referees of justice, and sometimes they're babysitters for full-grown adults with way too much free time. If this list made you laugh, groan, or double-check your own coffee cup, make sure to hit that like button, subscribe for more dives into the weirdest corners of human behavior, and share the most ridiculous lawsuit you've ever heard of in the comments. Who knows? It might end up in the next list. Until then, stay out of trouble, stay out of court, and if you must file a lawsuit, at least make it entertaining.